Lordship, this was heard, my lord, and Mr. Arvindo Mitro was directed or requested to mediate the dispute between the parties, my lord. A few meetings were held. Last of the meeting was held on 15th of October. Thereafter, my lord, there have been only exchange of emails wherein they have told that the representative of the defendant respondent is not available in Calcutta, hence the meeting could not be held. But kindly list the matter once, my lord. Probably by your lordship's intervention, my lord, it is at the fag end. This is the last one.
My lord, may I be permitted to mention one hearing matter? First appeal hearing for inclusion in your lordship.
The application.
Give.
Application.
Give all applications. Order 41, give.
Application.
Lordship, with the leave of the Mr. Justice Prashad, Lordship, I am mentioning for your Lordship. This is the Andaman matter, Lordship, application for modification in respect of a arbitration award,
Meeting
Lordship.
with whom?
Lordship.
Order was passed.
Order was passed by Lordship, your Lordship, and the Honorable Justice Rai Chattopadhyay, Lordship.
Give the slip. Let us see if we can sit one day.
Lordship, I'm grateful.
Non-prosecution one.
Oh, always welcome. Non-prosecution.
Your Lordship, may I be permitted to mention one contempt application passed by you?
By us,
Yes, sitting singly.
sitting
Lordship.
singly. You have to ask a leave first of my lord.
Leave.
Unless he grants you a leave, you can't mention the matter.
Take a leave.
What?
Take
May
a leave. Take a leave.
Your Lordship, may I kindly take a leave?
Yes.
Please.
Yes.
May I have a lordship leave, my lord? My lord, this is from an order dated 15/12/2017, wherein an order was passed for the decree of amount, and by then the payment was not being granted. So for which an appeal was made out, and the paper book is yet not filed by the petitions. We are for the respondent. So, my lord, if the matter be heard,
To be mentioned.
grateful, your lordship.
Permit to mention the matter for inclusion the list for hearing under hearing.
Give.
May I be permitted to mention one matter which was appearing before the Honorable Chief Justice's bench, and this, since my lord is not sitting today.
Be sitting at 1 p.m. because that bench is constituted with Justice Bhattacharya.
Lordship,
So please mention at 1 p.m. Come. Please see.
grateful.
I had the liberty to mention this matter. On the last occasion, I was told to complete the service. The service is now completed.
My lord, the order was passed on the 4th of October to file the affidavit in opposition, but they've still not filed.
To be mentioned.
But our matter is very urgent with regard to the license fee and hike of the license fee against the government of India in the first instance.
But this is not a bench constituted by the Honorable Chief Justice. We will be sitting at 1 p.m. Come and mention. Thereafter.
Yes. Well, this is relating to that violation of the order of injunction. Construction has been made.
Yes, then?
Then I filed an application for demolition of the same. The trial court is of the opinion that it should be heard along with the.
Oh, this is a temporary mandatory. I was not in town, so that is the whole problem with me. And today is some exceptional day also, so we don't know whether this bench will continue for the whole of the day or not.
As your lordship please as well.
Can you come tomorrow? I will just go through the file today and then we'll dictate it in the open. So, that's correct. It's fine. They could not. They could have sent it yesterday.
My lord, so item number 3, Mr. Arunna Chattopadhyay is representing the applicant. My lord, I'm kindly praying for not today, my lord. Due to the hefty traffic, he would not come to the court on time, my lord.
I'm appearing for the appellant opposite party.
First note is, no adjournment shall be granted in first 25
My
matters,
lord,
except where the request is made for adjournment at least 48 hours
my lord,
before
with
the.
assured evidence, I have seen that, my lord.
So
He could
why
not come to the
then
court on
will
time,
not-
my lord.
It is for orders, you know that this matter is going to be disposed of
My lord,
under the heading for orders. Then why?
my lord, due to the hefty traffic, my lord.
The hefty traffic, we also travel. We are also
My lord.
commuters.
My
If
lord.
we can reach, then why you can't? Start early.
My lord, the brief is still with him, my lord.
So whatever, then
My lord,
why?
kindly I'm praying for not today, my
No,
lord.
definitely, why should? He will take the entire day to reach to the High Court. It's a ground for adjournment.
My lord.
You are for
I'm
respondent.
for the appellant opposite party.
Then why you are standing in a respondent
No,
side?
here my lord opposite party, that's why.
My
This
lord,
application for recalling of the order, my lord, can
it's a review petition, my lord.
Section 9. The injunction which has been disposed of by your lordship in the appeal, whereby setting aside the order of injunction. Challenging that, my lord, or
So there is no other order. So let this matter go out of place.
the allegation was that the service was not
And
affected,
The
and I have
tendency will not deter in taking appropriate steps.
earlier occasion I have drawn to your lordship
And
attention that
this is
no
an
law
order
will
of for recalling.
recalling
My
of
lord.
that order.
Then
My
how
lord,
can it be done? This was an order passed by sitting with Justice Bissar. How can this matter come up before us?
No, my lord, the order was passed before your lordships only,
No, sitting with Justice Bissar.
my lord.
So it appears that an application is taken out to recall the judgment and order dated 6 September 2023, passed by the bench comprising of Amannam and Justice Bissas, the JJ. The said application is required to be heard before the said bench, and therefore where was wrongly directed to be listed today, let this matter go out of list.
Grateful, man.
Four my lord, the order impugned is passed by the commercial court. We go before the commercial division.
Then I'll have to take it out, take it back, and then go. Will not convert.
No, my lord, it was filed before the commercial division.
Then why it is appearing before us? The commercial division have filed it. No, here also. Just look at it.
Commercial appellate.
So it has not been filed here. Has it? You have filed it here.
No, my lord. It was filed in the 2022, my lord. Wrongly.
No, but then why it is appearing before us?
Wrongly it is appearing. It is sent by the department. Wrongly.
The instant matter pertains to commercial disputes and therefore has been wrongly listed before us. Let this matter go out of list.
I'm for the appellate.
So the different other category.
Well, the defendant in a suit for partition is the appellant before your lordship, well, challenging the order of remand. Now, well, what happened? The suit was initially dismissed. Challenging that, well, the plaintiff preferred an appeal. The appeal was dismissed. In the second appeal, my lord,
What is a suit for?
suit for partition.
It is against a preliminary decree or final decree?
Now, my lord, this is against the preliminary decree.
Preliminary.
Initially,
The remand was made by the first appellate court.
first appellate court.
Against that, you have come up.
My lord.
On what ground the
My
remand?
lord, the suit was remanded back. Suit was remanded back only on the ground of non-joinder of parties. Lordship kindly.
There is a section 5 application.
My lord, yes, I have filed and served. Can one, my lord.
183 days delay.
Yes, my lord, I have explained in.
Where is your affidavit of service?
Yes. I've served, my lord, both the section 5 as well as stay application. appear করেছিলাম।
What is the value of the suit?
My lord, 1,50,000.
By oh, so this is against appellate decree.
But the initially suit.
But this has to be heard by a single bench. Second appeal is heard by a single bench, 1,50,000. What is the ground for?
My lord, kindly come to the, my lord, in page 20 of the appeal court judgment. My lord, the suit was remanded back only on the ground of non-joinder.
On the ground of the condonation.
My lord,
What is the ground? Why there was a delay?
my lord, paragraph 2, 3, 4 and 5.
Huh?
Paragraph 2, 3, 4 and 5 of the application, my lord.
Can the austerity be ground for a delay?
My lord, 5 was misplaced, my lord.
That is a 3, but 4, 5. You can take, the help of the legal services authority.
Section 5.
Huh?
Down to, my lord. Short search করবে, section 5 is
Yes.
But actually, after remand, the plaintiffs have already participated in the hearing and their argument have been completed. They have filed the written notes of argument.
my instruction is date fixed for argument, my lord.
No, he says the written notes of arguments have already
Notes
been.
of argument filed by the plaintiffs.
Look at it.
And the argument for my lord, the other respondents, the other defendants are there. Plaintiffs, my lord, completed.
This is by the plaintiff, my lord. We are the defendants.
True, the defendants.
Defendants number?
Tell us what is your number? You were defendant numbers.
My lord,
You are a.
I am, my lord, the defendant number 1 to 7, my lord. But my lord, kindly consider the ground of remand, my lord.
Whatever, if you have already participated, you have already, now it's a suit at the, I would say, advanced stage of the judgment to be delivered. You have already submitted your written arguments. Then what remained?
Till that, my lord,
Then what remained? So at this stage of argument, then if we set aside the order, then what will happen? Entire exercise would be absolutely wasted. Go wasted.
Lordship, kindly appreciate, my lord, the ground.
Whatever, sorry. Then why you participated? What you were doing? 2022 you filed it. What you were doing?
14 September 2023, my lord, the written arguments have been filed.
Just imagine, after filing of this appeal, why you did not mention the appeal? The appeal was filed much earlier.
Yes, my lord, it's filed.
Application appears to have been filed on 28/4. The appeal must have been prior there
My
too.
lord, no, 2022, my lord.
So what you were doing for so long? 21/6, 28/11/2022. What you were doing? You ought to have immediately mentioned the matter. And you filed section 5 on 28/4. No, this can't.
My lord, only thing, my lord, that Lordship kindly consider this order has been filed in violation of section 99, my lord.
No, I appreciate it, sir.
Only
If
on the ground of
you accuse to your rights, if you participate, then what happened? That will it not I think impliedly be taken up that you have accepted this order, and after acceptance and implementing those and proceeded on that basis, can you challenge? Yes. You have accepted the order. What to do on a ground of delay?
No, my lord.
The delay was not at your behest.
My lord, instead of my lord, delay, my lord, since my lord, it is in the advanced stage, my lord, kindly.
No. I do not know what will happen thereafter. Yes. Not on delay.
No, kindly don't get me on delay.
That's your wisdom. Condoning the delay and thereafter. This is an application seeking continuation of delay in filing the instant appeal beyond the period of limitation provided. After considering the amendments made in paragraph 3, 4, 5 of the instant application, and upon hearing the respective counsels, we are satisfied that the appellant was prevented by a sufficient cause, not preferring the appeal within the period of limitation. Accordingly, the application for continuation is delayed. We are not going into that intricacies of those amendments about this next appeal. This appeal arises from a judgment and order of remand passed by the first appellate court. It is sought to be contended before us that there was no justification on the part of the appellate court in remanding the matter, as the appellate court could have disposed of the matter on the basis of the available, on the basis of the documents forming part of the record. Our attention is drawn to the fact that after the impugned judgment and order of remand is passed, the present appellants participated in the suit and in fact filed the written arguments. According to the learned advocate for the respondent, the matter is virtually complete after remand and have reached at an advanced stage where a judgment can be passed in relation to a preliminary decree. Since the appellants have participated in the suit after the remand is made and have further, they have examined or cross-examined the witness also. Evidence was laid.
So it has completed.
Evidence was adduced. And have further proceeded thereupon. How the sentence was and have further proceeded in progress thereof. We do not think that it is a fit case where the appeal should be admitted. Accordingly, the appeal is dismissed. No order as to pass. At the line लिखित हो. It thus appears that the appellants have no intention to challenge the said order after such participation in the suit, which is evident and apparent from their conduct as noted above. The first timer 6. It a first timer or आगे থেকে appear করছে? Who is appearing? Or leave to appear. Next.
Lord, I'm apparent. No, there is some defect, so I pray leave to cure the defect in the stamp report.
What are those defects, sir?
My lord, say in the trial court, the judges' names and dates are wrong.
These are all curable one, no difficulty. What is the valuation?
1,50,000. 1,50,000.
Then how
Partition suit.
partition suit?
Partition suit. My lord,
Decree of the first appellate court, district judge.
district judge.
So
Because partition commissioner, my lord, they have
against a preliminary decree or final decree, sir?
final, my lord.
Final. So what is the point? Say,
My lord,
point out
perversity point.
those defects.
My lord, perversity point. Because, my lord, on the partition suit, my lord, there
Yes.
because, my lord, in the partition suit, my lord, in the trial court, my lord, there on partition commissioner, before partition suit filed, that one fact has been already both the plaintiff and the respondents had already disclosed, but the partition commissioner did not take into account that. That's why we filed an application with the court. That was rejected. And partition commissioner, when
Application taking exception to commissioner's report. Did you file an application taking exception to the partition commissioner's?
my lord, my lord, my lord.
Then how the court dismissed it?
Your lordship,
Did you
kindly,
by the impugned order or by a separate order?
by impugned order,
The objection or is dismissed?
dismissed,
Is rejected. Okay.
rejected.
And it appears that the suit is decreed ex parte, sir.
Yes, my lord.
So where is an objection taking exception?
Plaintiff, defendant did not appear, my lord. When the
You are a plaintiff.
I am plaintiff. I am plaintiff appellant.
So
So my contention, my lord, because we have already sold the one portion of the plot, but when the partition commissioner filed the report, that report he did not consider that report. Your lordship, if your lordship come to the partition report of the commissioner, your page 19. My lord, page relevant page is page 21. Allotment.
no, this is a preliminary decree. Where is
Yes.
the final decree?
Okay.
Are you challenging a preliminary decree or a final decree?
Final degree, my lord.
Where is that final decree?
That is my annexure C. Page.
What is this annexure C?
Page 50,
What are
57.
you? What documents you have annexed with the memo?
My lord, page 57. Judgment degree passed on 30th November 2022 by the additional district judge 10 court, 13th of November 2022. Page 72, my lord. Page 76, partition commissioner did, however, admit that half of the second floor belonged to Kakulinundi's possession of the partition suit property. If it was the capacity of the owner, had a definite bearing of the shares of the partition. But
Just give us
my lord.
Yes. What are the grounds you have taken to assail?
My lord, partition commissioner report, your lordship, kindly come to the page 22.
No, tell me the grounds. 1, 2, 3, 4, 5. Tell me. It appears you have taken only two grounds.
Or only perversity.
No, it's not a perverse. Definitely not a perverse. Show us.
No, because the partition commissioner did not take into account that portion has been already sold to Kakul.
Did you disclose in the plaint?
Yes.
This particular portion was sold prior to the suit for partition?
Prior to the partition.
Why you included the whole of the property? Why? Why you included the whole of the property? Suppressing that this portion has already been sold to Kakuli. You did not disclose.
Disclose?
Where? Nothing. Not even in evidence you have brought. Ex parte, preliminary decree was passed. How the court will come to know?
No, my lord, when that commissioner report was filed at that time, we filed the objection petition. Because,
Sir,
my lord,
you are a veteran in the civil law.
My
A
lord,
property comprised of 4 kathas is a subject matter of partition.
my lord.
The plaintiff did not disclose that 1 kathas out of 4 kathas has already been sold to a third party.
No, this is a fact, my lord.
Proceeded on a base. I am against.
My lord.
Proceeded. I am giving a hypothetical example.
My lord.
The plaintiff proceeded as if the entire property is a 4 kathas.
My lord.
Preliminary decree is passed on the basis thereof. Final decree, the partition commissioner took into account, have given you some the portion according to your share declared in the preliminary decree. At this stage of the acceptance of the partition commissioner's report, can the court go into it that 1 kathas was sold? There is a suppression by you. Merely on your basis, you come to say that this is sold. Why you did not disclose it? That please exclude this. This is absolutely, or you can include it if everybody has sold, include it within that partition and make them a Kakulia party. As a co-sharer.
Your lordship, kindly 1 minute time. No plaint, my lord.
This is page 4. Second of the formulations. This is what, yes. Now he's coming.
My lord, in the plaint, nothing is there. My lord,
There is a finding which is made by the appellate court and the trial. So, how can you? And secondly, there was no disagreement. Your
my lord,
client
commissioner.
agreed and before the partition commissioner that
No, my
no
lord, only for
difficulty on
partition,
measurement.
in the, before the partition commissioner, my lord, he mentioned that Mr. Nondi is there. He partition commissioner report. But when the partition, my lord, included that portion included in my share.
So I
My lord,
understood.
I agree,
told,
I agree,
told
my
my
lord.
brother
There is some.
before you utter this word.
My lord, I do appreciate that. That is that
No,
is
this can't be. Can't be. You also sold that portion.
all both of them. Plenty and dependent both jointly sold. And that included in my share, that portion. That is the my lord.
So why you did not amend the plan, barring that?
That is my lord. I do. Both plaintiff and defendant, both of them told the party before party said, but there is not that filed the pen. That is there is some my lord.
And the Kakuli is living in which floor?
Kakul is in the second floor.
Second floor has been kept in common. So where is the difficulty?
No, my lord, that he has been given the second floor only.
No, common. That would remain a common.
Because he has already in the second.
So whatever everybody has to take it in common. You have been given a
Common
very.
is, but that is Kakul
Everybody
is
will
share,
have
my
a
lord.
common.
That is included in my.
Sorry.
Your lordship commissioner report that page 25.
No.
Page 25, my lord.
No, sir.
Pay
Second floor is, the
My-
partition commissioner says second floor would remain common to all the parties.
No, second floor 60 12 feet. Page 25. Page 25.
No, nothing. We go by a record.
First floor is entire to dependent. And ground floor, my share is 3 feet. And the opposite party share is 2 feet. So 3 feet, my entire second floor is only for 6 square feet. And entire other is Kakulin on this share.
No. Second floor will remain common with all.
No, my lord. Your lordship is
Let me show.
page 25, my lord. Only just
Wait. Just wait.
just page 25, my lord.
Yes. Please come to internal page 4 of the appellate side judgment, appellate court judgment. The valuation was accepted without demo and the allotment were consensual. I was just trying to say that. With both the sides agreeing to treat the second floor as common. So you have been given an exclusive portion. Second floor would remain common, then why you are breaking your head on it?
But second floor roof is common. Roof. That is not building. Is there. Second floor roof is common.
Second floor roof.
Roof, my lord.
Where is the second floor roof?
My lord, your lordship kindly come.
Is on a second floor.
Your lordship kindly come to page 25. Just one commissioner report, my lord. Only commissioner report. That on the basis of the valuation report, my lord. Your page 25. Page 25. Your lordship. Page 25. Structure ground floor 525. First floor entire to opposite party and second floor 60 square feet. 600 square feet.
Entire ground floor will come to you.
No, ground floor only for 5, some portion. 525 square feet. And entire first floor is 729 square feet. Entire has been opposite party. My is 525 and other is common. And second floor is 600 square feet only.
So royalty money is to be given to you.
But 6 square feet is including Kakolin on this share that we have already sold. That is the problem. My share is including the Kakolin on this. And we filed an objection. That is was also rejected.
And and page 22, that allotment is second floor to the entire, but budget of the plaintiff to 9% of the 9 year plaintiff কোথাও নেই যে আমরা ওইটা কি করে দিই কোথাও কমিশনারের কাছে এই তো এখন ধরে চলছে time will not do things.
Where is your objection? Where is your objection? Sir, have you not?
My lord, it has been not included in the brief, my lord, that is. Agree.
Your objection is turned down and you do not know where is the application taking a objection. Sorry, we have invested lot of time just to save whether there is any kind of a thing that should come. No, we do not find anything. We'll go by this. Sorry, we can't.
My lord, only, my lord, not today, my lord, tomorrow, my lord, only not today, my lord.
See the commissioner's report?
My lord, objection petition is not in the file, my lord, your lordship, only for one.
No, definitely not. Definitely not. Sir, what is your, come to page 23. Now I am taking you. Forget about the objection. Come to page 23.
My lord.
Serial number 4.
Serial number 4.
Allotment.
Allotment.
Read.
The plaintiff submitted to allot ground floor and second floor.
You are a plaintiff?
My lord.
So, if you yourself has said that please allot me a ground floor and a second floor, and the commissioner has appointed you, what is the difficulty? Where is the difficulty? Unnecessarily.
May I take his lordship's leave, Lord Mayor? Just
Yes.
Lord, in the commissioner admits that the part of the first floor has been sold. This report it's
Why you did not disclose in the plate?
that
He
the-
has already said.
Yes.
We put a question. Then,
Admitted, it is admitted
sorry,
fact.
and then before the commissioner also you said, no, I want this.
But that is there, but part of the,
If
that
the
floor,
admission will go,
That's all.
commissioner
that admits the fact, but it is not.
there is no
uh,
admission
subject
of
to correction,
facts
my
in
lord.
that.
That-
If you said, please
But
allot me.
I might,
there is no
subject to
difference.
correction, I might not have included in the plaint, it predate in the plaint, it's a lawyer's fault anyway, but thereafter, my lord,
So,
my lord, when my lord, it was brought to the notice of the landed commissioner and the landed court also by a.
can it be then the question of importance of pleadings
it's
in
a absolutely,
a
but
adversarial litigation?
but-
These
but-
provisions under the code of
Absolutely,
procedure
but
has
it's
to
a
be torn
partition
off
suit. But
and then
But
throw
it
in a
is a
river
parti-
Hooghly here nearby.
Absolutely, I bow down, but it's a partition suit, my lord. If not subsequent events take place, even
Sorry,
the commissioner,
no,
the court
no,
can take into
no,
consideration that.
Definitely no.
That the some part of the property is sold, that cannot be included and
It was
given to
told
the-
prior to the institution. I asked
by
him.
the- and yes, absolutely.
So,
But by the all the
You can
co-sharers,
understand that it is
by
during
all the
pendency
co-sharers,
only.
but it is not by the plaintiff allowed.
Whatever be, that the
So-
next party you were happy
Uh,
when you included the entire
But
shares.
when
Sorry,
not admittedly, when part of the
Sorry.
property has been
Sorry,
sold, that
don't
cannot be
fight.
allotted to one of the
No.
co-sharer.
sorry.
But admittedly, when it is admitted fact, otherwise it will
Come.
be injustice, brother. It will be grave injustice. One part of the property which has been sold by the joint co-sharers and is allotted to me, and that value, brother, I have to pay that.
A beleaguered, the
But kindly-
appellant is beleaguered between the admission made before the commission, partition commissioner,
The admission is that, brother,
the stand taken on a factual matrix which is conspicuously absent in the pleading filed by the plaintiff appellant
In the plaint.
in the partition
in the plaint.
in the partition suit. The suit for partition and separation of say was filed in respect of a suit property with the sufficient description as required under the provisions of the codicil procedure, treating the same to be an undivided property of the parties to the proceedings.
There's one paragraph only, brother. One paragraph, page
We do
27.
not interfere,
Right.
treating those as a part of the undivided property. So, the record would reveal that the suit was decreed ex parte in preliminary form, declaring the share of the plaintiff and the defendants, which is not a subject matter of challenge in any proceeding. The court thereafter proceeded with the final decree, treating that the parties have no dispute with regard to the shares declared in a preliminary decree, and appointed partition commissioner. The partition commissioners measured the property in presence of the parties, and it is reflected from the report that the counsels appearing for both the parties did not raise any objection on the measurement done by the partition commissioner. The report would further reveal that at the initial stage of the commission, the parties agreed to have the valuation of the aforesaid property, and accordingly, a direction was passed by the commissioner in this regard. The valuation report was submitted by the parties, and it would appear from the said report that both the parties, through their lawyers, admitted such valuation report received from the registry office without any objection.
That objection taken in the order, order itself.
Without any objection.
Not subject to correction. Kindly pardon me. Not the Director Court observed that the objection that part in the while accepting the report of the commissioner, page 57. Kindly not bear with me. Page 57, just for my satisfaction once.
I think you are a veteran having a long.
No. I'm still running. Not kindly pardon me for me. Page 57.
What we are dictating. We are dictating what we perceived from a commissioner's report.
But thereafter, while the trial
We
court,
have not reached that stage while dictating the order. We have not reached the stage
trial court has
of
recorded that.
of this.
I'm sorry.
We are still at the stage of the commissioner report says we are saying.
No, thereafter, trial court, while accepting the commissioner's report, records my objection to that part. That's
Either you dictate.
No.
the order
I'm
or
sorry.
let
I'm
us
sorry.
dictate it.
I'll leave it to you, Lordship. I'll leave it to you.
When you draft a plate, there is a sequel of events.
Absolutely, I bowed out. I
When we dictate the judgment, it is also dictated in a sequel of events.
I bowed.
We have said that what the suit you have filed. We have said that what the preliminary decree is. We have said that what the commissioner report is.
No, just now your Lordship recorded that there was
Yes,
objection on part.
it would appear, we record. What does it mean? We have not said it would appear from the report that both the parties have not raised an objection. Then we will say that subsequently, if the objection is raised, whether that is sustainable. You have not allowed us to reach that
I'm
stage.
sorry. I'm sorry. I beg. I beg. I'm sorry.
And I appreciate the other high court's procedure that they do not dictate in the open court because of this, and they dictate in the chamber after declaring that what they are going to do.
But it is also our duty to point out the correct facts so
that is what I say. It's a duty to listen the order with the open mind, not with the closed mind or towards inclined towards the interest
has
of your
already
client.
indicated your Lordship's mind.
We have not reached the stage of objection as yet.
I'm trying to espouse to convince your Lordship.
Do not. You have not been able to convince us.
No, that was I was trying that the objection taken in the.
Where is the objection? You have not included the objection in the file. Objection taken orally.
No, the objection is there.
Where is the objection? Where you have included it in the paper?
It's in second.
So whatever the court has recorded, the recording made by the court is sacrosanct.
Yes, but I am also relying on the recording of the
Sorry.
court. This objection is recorded in the trial court.
Where is the objection?
But page 57.
Where is the objection?
No, objections right
Is
now.
not there.
I have in file.
Was?
Page 57, the records of objection.
Not.
And you see the page 57. Page 57. The objections are contested hearing while accepting the commissioner's report.
We know it, sir. And whatever was the objection is also reflected in the order.
Yes, that was.
And what he's saying is something completely alien to that objection.
Absolutely. That's why I wanted to correct my.
You did not have.
Not,
it would appear from the said report that without any objection. This is what the language is used. The record would. Now, it is further evident from the said commissioner's report that the plaintiff's appellant unequivocally submitted before the commissioner to allot the ground floor and the second floor. And the other and the defendant respondent showed their intention to have the first floor. On the basis of the aforesaid submissions and the consensus perceived by the commissioner during the currency of the said commission work, accepted the respective decisions and proceeded to allot the ground floor and second floor to the plaintiff appellant and the first floor to the defendant respondent. However, the other portions where the drainage, septic tank, staircase, and the electric rooms are concerned, the commissioner indicated that apart from the electric room, the other facilities and amenities attached to the said premises would remain in common. And further, directed the defendant respondent to arrange the separate electric arrangement in the first floor within a stipulated time. The said report was submitted before the court, and curiously enough, an objection was taken out by the plaintiff, taking exception to it. It would appear from the findings returned by both the courts below that the first objection relates to a sale of a portion of the second floor to one Kakoli Nondi by all the co-sharers / owners, and therefore the partition commissioner should not include the said portion as jointly owned by the parties while allotting the same. The second objection relates to the second objection relates to that certain portions of the properties have not been allotted to the plaintiff appellant, and in fact the kitchen, which is shown in the report, has been demolished. It does not appear from the findings made in the impugned order that any other objection was taken by the plaintiff appellant against the commissioner's report. Obviously, the moment an objection taking exception to the commissioner's report is filed, the court invited the commissioner to appear and adduce evidence in support of its report, and it is undeniable that the said commissioner was extensively cross-examined by the plaintiff appellant. Both the courts have rejected the said objection, firstly on the ground that the sale of a portion of the second floor to one Kakuli Nundi was suppressed by the plaintiff appellant in the plate and was sought to be disclosed for the first time before the partition commissioner without any evidence or proof in this regard. Both the courts have further held that the other objection relating to demolition of the kitchen cannot be taken into account having no relevance and or proof at the behest of the plaintiff. Next one. As indicated above, the shares held by the parties in respect of a property is not disputed. Though in a partition suit, there is no concept of plaintiff and a defendant, as each parties are litigating for their share held in the joint property. Full stop. The plaintiff, neither the defendants, ever disclosed in the plaint or in the evidence that a portion thereof was sold to Kakuli Nundi, who is also one of the share, where one of the co-partner or the co-owner in respect of the joint property. Rather, the plaintiff appellant proceeded on the premise that the entire property is held in joint by the plaintiffs and the defendants, and in absence of any such document or the pleadings having made in this regard, the court proceeded to decree the suit in preliminary form and ultimately proceeded further to pass the final decree. Even the report would reveal that the plaintiff's lawyer, who was present at the time of the commission work, submitted that the plaintiff should be allotted a ground floor and the second floor. Whereas the defendant appellant's lawyer conveyed the intentions of his client that the first floor may be allotted to them. Since there was no dissent before the commissioner in respect of a respective allotments, the commissioner proceeded to allot the same as desired by their respective parties, which cannot be said to be unreasonable, irrational, or having any flavor of a bias. Full stop. It is an ardent duty of the litigant to disclose all the relevant facts. And having suppressed the same, the court cannot, and having suppressed the same, and later on found to become a counterproductive, no blessings from the court can be expected. A litigant cannot take a rebound to what has been pleaded and the evidence having adduced in the suit, and say something which is dehors the pleadings and the evidence, and the court, in our opinion, have discarded and rejected the aforesaid contention, which cannot be said to be illegal, infirm, and susceptible to be interfered in a second appeal. Since the orders were passed, taking into account all such aspects, we do not feel that any substantial question of law is involved in the instant appeal, the same is hereby dismissed with costs assessed at 10,000 rupees to be deposited with the state legal services authorities.
Appellant is a member of the
Is a state legal services authority.
member of the bar. We are not taking any fees. But kindly expert. Member of the bar. We are not taking.
Why you did not disclose it?
This is
That
fault.
the plaintiff is a
is
member of the
fault.
bar? Why?
No, I did not want to.
Which court?
Not Alipur court.
Why
Kindly
you did not disclose?
No, that I should not.
Why not? Because that is, we don't take any matters concerning the member of the bar. Even I believe my brother will also join. This is not expected from you.
I should not. I
Sorry.
thought if I
Sorry.
read something, I don't want
For
to prejudice.
10,000.
No, kindly bear with me. We are just doing this. Kindly exclude that part. But I do not. I don't want to prejudice not by taking the member of the bar. I do not take to any advantage being member of the bar. That's why I did not point out.
No.
Kindly, that cost part, my lord. Kindly cost part, my lord. Kindly, my lord, discuss that part, my lord. Old lady, my lord, she's out of possession of the property. That's why, my lord. Kindly, my lord, exclude that part, my lord. My lord, oblige, my lord.
I will.
My
I
lord,
will impose. I do not know if my
my
brother
lord,
agrees.
please, I'm not
I will
only
agree
humble,
with
my
him.
lord. I
Convince him.
beseech your lordship, kindly, my lord. Let's poor lady, my lord. She's
If my
not
brother
being a
says
professional.
otherwise, then
But I'm beseeching your lordship, my lord. My lord, kindly cost part, my lord. But one part of the property, she's out of possession. She's not in a not sound position financially. That's all. Kindly, my lord, I'm beseeching your lordship, my lord.
My lord, justice.
You're not doing this professionally, my lord, this case, my lord. Kindly bear that part, my lord. Kindly. Lord, this is not, my lord, even she could not pay the fees, even all these typing costs borne by me, my lord. Kindly, lord. Just, my lord, kindly that part, cost part, my lord, kindly expunge that part, my lord. I'm beseeching your lordship, my lord. I would not have done for the client.
yes, call the next.
My lord. My lord. My lord, I expunge that part, my lord. Kindly, my lord. Please.
Yes.
My lord, this is the matter, my lord, in which Mr. Mukherjee, my lord, in fact, on the last day,
That there should
very
be a
fairly
further
said,
reference or
very
not.
fairly said that yes, it has to be admitted because
So
the
I did not say it has to
no,
be
very well,
admitted.
very
I
well.
said, Lord, whether appeal lies or not.
Oh,
The
this
Lordship on
is-
the last occasion was
No,
of
but we
opinion
were
that
thinking of referring the matter
yes,
to a
that is
further larger bench.
because three judges, Lord, two judges have, Lord, gave a different, Lord, view, but although, Lord, they are converging on, Lord, the point.
So we are sending it to a further larger bench by judge.
And in the meantime, kindly give me protection, my lord, because I'll tell your lordship. My application, I was the defendant, my application was under Order 7, Rule 11 of the Code of Civil Procedure. That application was allowed, resulting in a decree. Naturally, my lord, they had preferred an appeal from decree. The appellate court had allowed the appeal. My lord, in fact, the order of reference from which, my lord, this three judges bench had, my lord, passed this order, I know. That order also records that, my lord, the only thing is, my lord, in that case, a second appeal.
That is the minority view. That is a view expressed by the single bench or a division bench. I do not know. That is what is. But ultimately that view is no longer a good law in view of the larger bench having decided that point.
No.
That may be because why the reference was made, the judge has to indicate that I am unable to persuade myself to agree on these grounds, the proposition of law laid down by a coordinate bench. That's why the court refers.
My
So
lord,
these findings are tentative.
the issue, my lord, which was referred was that, my lord, if, my lord, an application under Order 7, Rule 11 is dismissed, and my lord, the defendant, the applicant goes, my lord, in revision, because it has to go in revision. Order passed in that, my lord, what would be, my lord, the next course of action? But so far as, my lord, is Order 7, Rule 11 is allowed, and, my lord, may I read out the, my lord? Sorry.
Yes, yes.
May I read out the order of reference? It says,
To recapitulate the, or to tax the memory, or to refresh the memory.
feel on korte debe na.
Yes, yes, proceed. Proceed. We are referring to a larger base. That's
Very well. Kindly protect me. In the meantime, my lord, what I am on is, my lord, in the meantime, my lord, there are decrees passed in the suit. I have to, tomorrow, my lord, I have to file my written statement. I have to take all steps. And, my lord, the suit proceeds. My lord, that should not be allowed to be done.
yes, where is the order of reference? That is by a single bench.
Yes. Yes. Kindly come to the order of the special bench, my lord. Kindly come to the order of.
Lord, it refers, Lord, in
Yes, the
italics,
first
not
page.
I am looking at my judgment.
Why?
You were placing this, the order of reference.
A portion of it is quoted, my lord, in this. আমি জানি ওটা আমার কাছে নেই আমি দেখি কি আছে না না ওইটা নয় জজ সাহেবের রেফারেন্স এটা যেটাতে অর্ডার রেফারেন্স হয়েছে
Mr. Chakraborty should have it.
হ্যাঁ
Mr. Chakraborty, it's in the file.
my lord if your lordships are my lord looking into the order of the special bench.
No, I am looking at my order. It says, from the holistic reading of both the judgments, this court feels that they are ad idem on one proposition of law, that the nature of the order would be a deciding factor for further remedy to be exhausted by a agreeing person. And it would be totally irrelevant whether such order has been passed in the divisional jurisdiction or in appeal under section 96 or in appeal under 104 as well as an order 43 of the This court, there cannot be any doubt, not this court has any doubt on the above enunciation of law. Yet, this court feels that the other provision which assumes importance and relevance to an issue, which is slightly different from the cases before the division bench, requires a little drift therefrom. Then subsection 2 of the court defines a decree, and then it is there. Then I say I'm not oblivion of the other lines of the decision rendered by the division bench, more particularly in case of Surajmal Jain and Prabir Kumar Seth, where the division bench was considering the categorization of the appeal filed against an order determining the rights of the parties under Order 21 to 91. And then we have quoted all these things. Rather not, I have quoted those. This court says that this court therefore notices a conflicting view on the proposition whether the nature of the order is the sole and primary factor to ascertain the remedy available to a aggrieved person, or it would be dependent upon the nature of the proceeding filed before the court and the power vested under the relevant provisions is exercised. To be more precise, whether an appeal or the revision would be the remedy if the nature of the order is such which comes within the purview of the aforesaid provision of the court, or it is a proceeding itself filed before the court would be the guiding factor to decide the remedy of the aggrieved person. This is what we have said. I have said.
Well,
Thereafter,
only
I referred
one
the matter
one
to a larger-
portion, only one portion. Kindly come to the next page, page 4
of
of your
my order.
Yes, yes. It yes, Lordship's order.
Yes.
Yes. Kindly come to page 4.
Yes.
Well, the third paragraph, which starts with "there is hardly any dispute."
That is not in page 4. Anyhow. 1, 2,
না জজ সাহেব তো নিজের অর্ডারটাই দেখছে
3, 4.
আমি জানি এটা কোন অর্ডার ও I see. My lord, kindly come to the three judges bench order, my lord, where a portion of your lordship's order has been quoted. Very well, observation, very well.
Yes.
Kindly come to
There is hardly any dispute that in view of the nature of the order passed, more particularly the definition of a decree, the appeal lies before the appellate court. As such order neither comes within the peripheral limit of 104 nor under Order 43 Rule 1, but under 96 thereof. It is not always necessary that the formal decree is to be drawn up if the court expressly provides. If the court expressly provides that such order would be a deemed decree, the appeal can be maintainable before the appellate forum. This is what. That is why later on, that's why I say, I am conscious. So I say that I find, this is what I said, after holding this.
Absolutely.
I say that this court therefore notices the conflicting views of the coordinates. So therefore I referred the matter to a larger. So my finding cannot be said to be I would say, absolute or sacrosanct. It is only in furtherance of a reference to be made to a larger bench. Not an, I would say, the expounding the law or the expression of law held by the bench.
very well. Kindly send it, my lord. Kindly send it, but kindly give the protection also. Well, otherwise, kindly consider the situation. A decree is passed against me.
Yes. So what remained? All these judgments were cited because at the time of reference, after the reference, special bench made certain observation at page 5.
Yes. Page 5.
Then what remained to answer? Page 5. The earlier larger bench, then quoted. If the first 5 line was the correct view, then there was no necessity to. Yes. Requiring so much time to read. First 5 line was the final opinion and the expression of law. See. The reference appears to the larger bench was erroneous in view of a well-settled proposition of law emanates from these 5 judgments. Then, so what are these judgments? Yes. Oh, these judgments were relied upon. And in paragraph 13 of the larger bench judgment. No, we are referring it. Protection before the larger bench.
Protection before the
Yes.
with the protection, my lord. Not without any protection. হ্যাঁ, কবে হবে তার কোনো ঠিক ঠিকানা নেই। না, তাহলে পুরোটা দেখা যাবে। হ্যাঁ, আছে। বৃহস্পতিবার submission.
Yes.
proceeded with. If suit proceeds with, my lord, there is no point in coming up before the court.
Let us come. Mr. Mukherjee, we want to hear out the matter, keeping that point of maintainability of that. That should be discussed. That will definitely decide whether conflict is there or not. Apparently appears to us. We are doing that. Yes. Appeal is formally admitted, subject to the maintainability of the instant appeal. Mr. Mukherjee, we want to hear out the matter, keeping that point of maintainability of the judgment pronounced by the will definitely decide special bench whether conflict is there or not. Apparently appears to us. We are doing that. Point involved, the substantial question of law
Appeal is formally admitted,
subject to, as it appears to us, maintainability of the instant appeal. Whether the second appeal is competent
point of maintainability of the judgment
against an order
will definitely decide
passed by the revision
is there or not. Apparently appears to us.
passed by the regional jurisdiction involved, the allowing an application under Order 7 to 11 of the Code of Civil Procedure. When such revisional application was filed,
It was from appeal.
this was from appeal. Oh, sorry. The other one is whether the second appeal is competent against an order passed by the appellate court in an appeal
From the
against an order rejecting an allowing an application under Order 7 to 11 of the court. Our Supreme Court. Sorry. Yes, don't interfere. Whether further appeal under Section 100 of the Code of Civil Procedure is maintainable against an order passed by the first appellate court, allowing the appeal, thereby rejecting an application under Order 7 Rule 11 of the Code of Civil Procedure. Semicolon. In other words, whether the nature of the order is a determinant factor for invoking a jurisdiction or nature of the jurisdiction exercised by the Court of Appeal below shall be the guiding factor in pursuing a remedy by a litigant before the higher court. Since the matter involves a pure question of law, we do not feel that the difficulty is the second appeal.
Single bench division.
And we have to admit, if we admit that
It goes to the single bench.
and if we do not admit, then my own judgment is staring at your face. The difficulty is because of 2016 volume 11 SSC. So Apex Court has said that unless you admit the appeal, you should not pass an interim order. Then we can't pass an interim. I have it. My brother was not a party to that judgment, but I have already. So I have to go by that. So this is how the problem arises. then we can't pass the interim order. There are two things open. I tell you very frankly. If you want this bench should decide, then we will not pass any interim order. Absolutely clear. If we admit the appeal, then we can pass an interim order, but it will go to a single bench for final decision. Choices. These are the two courts of it. We are inclined, but we can't unless we admit the appeal. That's I have a difficulty.
The whole difficulty is, my lord,
So that I appreciate. That's why I'm saying. So let it go to a single bench then. My own judgment is. I'm bound by my own judgment.
kindly give the protection, my lord. That
What protection? Then go to the single bench.
From the single bench, we may
Go to the
pray
single
for an assignment over the division bench. If I may assist Mr. Mistro with that.
Or both of you, if you want, you have to take steps somewhere.
Lord, once it goes to the single bench, we may pray for assignment, Lord, before the Honorable the division bench.
kindly admit the appeal, my lord. The whole difficulty is
We have got, there is a point, no doubt about it. The point needs to be addressed. Needs to be addressed. We are quite sure about it. No doubt. There are, that's why we expressly indicated to you, there are only two courses open. First thing is, we can't pass an interim order unless we admit the view. Then we will decide the maintainability by ourselves.
no. Can this? I'm sorry.
Secondly, though we are convinced that it really involves a substantial question of law, so we have to formulate, that's a mandate under the section 100. We have to formulate the substantial question of law, which we did. Then in that event, we can't hear out the matter. It has to go to the single.
Can this be done, my lord?
This is the third way.
Can this be done? Now, my lord, can this be done that, my lord, the appeal is admitted subject to question of maintainability to be heard by this?
What we dictated. That is what we dictated. But we loses the determination.
For the timing, it's admitted subject to the question of maintainability to be decided.
After admission, we don't. Then it has to go to the single bench. Keeping that point of maintainability open. That would be one of the substantial question of law involved. The appellate, the single bench will decide that.
Kindly, my lord. Apparently, my lord, I can tell your lordship that, my lord, from the reading of this, my lord, three judges bench order also, which quotes the order of reference, there is no dispute that a second appeal lies. In fact, my lord, 96, the only thing is, my lord, 100.
Difficulty is the nature of the order is nature of the order is such that it dismisses your application under order 7 rule 11.
Yes.
If the nature of the order, then rejection of order 7 rule 11 does not satisfy the definition of the decree, and the difficulty, then you are propagating a proposition of law that it is a jurisdiction which is a determinant factor. What jurisdiction is exercised by the court?
Yes.
But the judgment of Justice Sen is not the jurisdiction. It is really a nature of the order. then that really is a point. And whereas Justice Chandro's view is that if it is a situation, literally, though he says nature of the order, but he literally says the jurisdiction is the important fact. So this kind of a conflict has to be resolved. What to do? That is
Lord,
what,
may I assist Mr. Mitra once, my lord?
yes.
Lord, we make this submission that after admission, we may pray for an assignment before this honorable court for decision on the basis of the nature.
If it is valid.
No, this is what is then what I said when I indicated what this was the indication.
After, when
I
it
see.
goes to the single bench, when
Yes.
we then may jointly pray for an assignment before the honorable the division.
Which I
Yes, yes. We do that.
Your lordship, please.
ठीक है sir. That the bringing the lower court record or preparation of the paper book would subserve the justice. So, in view of the above, the filing of the paper book and bringing the lower court record are dispensed with. Since the parties have entered appearance at the admission stage, the service of notice of appeal is waived by the respondent. Respondent number one is a plaintiff.
Respondent number one is the plaintiff,
Yes.
Lord, and
Yes.
there are other
the-
respondents, Lord, they have been very.
They have not approved. Since the respondent number one, who has instituted the said suit, has entered appearance before us, and the other respondents are in effect the defendants in the suit and have not assailed the impugned order, comma, the service of notice of appeal upon the other respondents are also dispensed with. Since a point of law is involved, as framed herein above, being a substantial question of law, comma, we feel that in the event the suit is proceeded with and decided finally, it would have an impact in the instant appeal, and therefore we feel that an interim protection is required to be extended to the appellant pending the instant appeal. There shall be stay of all further proceedings in title suit.
My lord, it is kindly give me page 6.
Title
Page 20.
Title suit number 1197 of 2022.
Yes, 1197.
Before the Learned Civil Judge, Senior Division, 4th Court at Alipur for a period of 6 weeks from date or until further order, whichever is earlier.
But I just, Lord, the suit may proceed, Lord, without the decree, Lord.
No.
The decree will only be passed after, Lord, the appeal is decided.
Kindly not.
Suppose what will happen, Mr. Mukherjee? You are a veteran in a civil jurisdiction. Suppose the court ultimately finds this court that the rejection was wrong.
I understand.
The consequence which would follow therefrom is the rejection of the plaint. And if the plaint goes, then all these pleadings which has been disclosed,
the difficult
that will sometimes go against them, because they may be those pleadings may be treated as a part of the evidence in any other proceedings. So that is what we do not want.
But I am enjoying an order of injunction. But I am just apprehending, Lord, that there might be some events which I need to draw attention of them, Lord, the trial court. That's the reason I said. I'm enjoying an order of injunction, no doubt about it. But if something happens, my lord, I have to come and disturb your lordship rather than, my lord, I could have gone to the trial court to, my lord, make out any application in furtherance thereof. That's the reason I said that it's
Stay
not,
of
the
further
decree
proceeding
is
does
not
not
ultimate.
mean, stay of further proceeding does not mean the stay of the interlocutory proceeding.
But that is true. Absolutely, my lord. I'm not on that. If
Anyhow.
any application is required to be taken out and
Both of you, in your wisdom.
Lordship.
Let the application for stay be listed before the appropriate court.
My lord, applicant for the advocate, C is engaged in courtroom number 41, my lord. Therefore, my lord, I am appearing for short passover.
विनोद ये आगे मैटर देखना आगे मैटर है yes madam
Advocate for the appellant, C is engaged in courtroom number 41, my lord. Therefore, my lord, I am appearing for short passover.
who is appearing
Miss Devjani Sengupta.
no where is the Saptarshi Datta sorry Shayan Dev Kumar
She is an advocate on record, my lord.
where is he
She is not.
where is the advocate on record are you briefed in the matter are you briefed in the matter
No, my lord.
Passover call him
Ten in this matter, my lord, I am for the appellant. Earlier occasion, your lordship direct me to serve the copy of the application upon the defendant opposite respondent. But I have served the copy and my lord, affidavit service has already been put for your lordship.
Mr. Devdatta Vasu is appearing on behalf of the respondent, my lord. He is on legs before my lord judges. Mr. Devdatta Vasu. Very short passover, my lord. Mr. Devdatta Vasu is on legs before.
what is the nature of the appeal
My lord, regarding my lord, the suit filed by my client as plaintiff, my lord, suit for eviction on the ground of reasonable requirement. And my lord, the suit was decreed. Against that, defendant filed an appeal on the ground that application order 16 rule 14 of the Code of Civil Procedure is pending. They have taken the point before the appellate court that one application has not disposed of by the trial court, even if he have decreed the suit. On that ground, the appeal admitted and remanded by the trial first appellate court. Against that, I come before your lordship. The application which was raised by the defendant before the lordship, that application was heard and disposed of. In the trial court judgment, my lord, the trial court come to a conclusion that the application is not maintainable because he is a stranger. The court has the power to ask the stranger in the witness box or not. That is the discretionary of the court. As a result, this court, my lord, decreed this suit. Now, the second appeal before your lordship, again the remand order. The reasonable requirement degree has been passed.
call him
2 p.m. At 2 p.m. as your lordship. As your lordship, 2 p.m. 2 p.m. as your
why
lordship.
2 p.m call him
As your lordship desired, I am not.
call him
It's my appeal.
Well, kindly recall.
so this is 118 square feet
Yes.
so it does not talk about that every floor is to be given
No.
so
Lordship, I'm talking instruction, Lordship. Lordship, just kindly see the impin order once again.
Yes, we are looking at the agreement. We are looking at the agreement. Yes.
Kindly see the appeal order why the learned trial court has decided to appoint the receiver.
I'm just looking at it. Show us that
Yes.
what is your right.
Lordship. Kindly see the internal page 2
Yes, we are looking at that.
on perusal of the record.
Impugned order or agreement, you said?
Impugned order.
Oh, impugned order. Yes.
That is page 46
Yes.
of their application.
Yes.
The reasoning. On perusal of the record, it also appears that this court has granted the order of ad interim injunction in the form of status quo by order dated 30th September 2020 against the defendants, and the said order is time to time extended and still subsists. No, Lordship, this order has not been annexed with their application. Kindly see the order.
How an order of injunction has any
Yes, that
bearing?
is
I'm asking you, how an order of injunction has any bearing in an application for appointment of receiver?
I think, Lordship, I would like to satisfy you, Lordship. Just kindly see the order for a moment.
Yes.
So, Lordship, we kindly see this injunction was filed by the plaintiff, my client. So, the injunction was specifically praying for injunction against the defendant not to induct the tenants in the suit property anymore, because this is a partition suit.
Yes.
And the learned trial court, while order dated.
No, this was there that a status quo with regard to nature, character, position, and not to create any third party.
Yes.
That's all.
And thereafter, they started violating the order. They started inducting the tenants.
Go there under order 39 to
Lordship, that was the reason where the court took it seriously.
I'm asking you whether this is a fit case for receiver.
Lordship, I'm coming to that point. Now, this was the first reason what the court felt that when I have granted injunction against you not to bring any third party anymore, the partition suit has to be decided. You continued inducting the tenants. You continued creating the third party interest. That was the first reason what the court granted the receiver. And the second ground is, Lordship was asking me, what is the right, what is your right? Lordship was saying the agreement. The agreement. This is the agreement. Lordship, may kindly note down the date of the agreement.
2010.
2010. At that time, the premises, the construction was not there. The premises was not constructed at that time. Subsequently, after entering the agreement, it was agreed that I will get 118 square feet.
This agreement really indicates your right in respect of a to be constructed structure.
Absolutely correct, Lordship.
Can you expand beyond the right which you have agreed in the agreement?
That is what I'm trying to show, Lord. Can you see the agreement? Paragraph 3.
Yes.
That the first party shall be provided with an accommodation of 118 square feet, which is fit for habitation in the third floor of the proposed building in favor of the second party. And if the FAR be excess found from KMC, the measurement of area of the second party will be enhanced according to the law. Now, this FAR excess was naturally, Lordship, after the issuance of sanction plan, when sanction plan was granted. At the time of the execution of this agreement, there was no sanction plan, no FAR was provided to us, to my client. Now, after the sanction plan was granted, the building now took the shape of 4-story, probably 4-story or 5-story building has been taken into shape. FAR has become exit. We approached my brother that now, because of this agreement, now you increase my share, which was not done. I filed the partition suit. When we filed the partition suit, we found that despite filing the partition suit, they started creating more third-party interest there. Injunction was passed, order was specially passed by the trial court not to induct in third-party. They violated the order. Now these two were the reasons.
I understand whether this tantamount to appointing of the receiver. I just want a very simple question. This is the fourth time I am repeating.
Lordship.
tell me that these can be a ground for appointment of the receiver.
Lordship, I'll just, Lordship,
Just one simple. You have been provided with 118 square feet. It is not an dispute.
so it's a dispute. That area
They
is
say
also-
that you have been provided.
They are saying we are not
Now,
accepting that.
question is, if the other portions are being dealt by them, whether you can go. And ultimately, if you get it, then you will get it in a unencumbered position. The court will take care of that.
Lordship, in this situation, there is one judgment of the Honorable Supreme Court also, where it has been held that in this situation, if there is found that the person or the question who was receiving the share, if he has, Lordship, I'm just showing the judgment. Lordship, 1 minute. Some mix up. Also, in one of the judgment, it has been held that also that even if the receiver has been appointed, whether it causes any prejudice to the other side, whether it causes any prejudice to the other side,
I believe the ground of prejudice is not relevant for the purpose of appointing
that is
them.
one of the judgment. I will
Let us see. Let us see.
19.
Simply because it will not cause any harm, so the receiver.
Supreme Court, this is our High Court Calcutta.
19 Calcutta 229.
The Calcutta judgment. It's a single bench judgment.
Single bench in CO in 27.
So
Paragraph 15 and 16.
we as a division bench,
No, I'm not saying that. I'm just trying
as
to
a division bench, we do not know, and there is no judgment which has been referred here relating to the ingredients for appointing the receiver.
Lordship. There was the other judgment, I think.
Have you brought the judgment of the Madras High Court?
I have not got, but I've taken it. I've personally looked into it. I've personally looked into it. It calls out the
1, 2, 3, 4,
guidelines.
5, 6,
Yes.
everything has been given. Those are the. Have you got?
এই ওর ডাউনলোড করা ছিল মোবাইলে ওই শিক্ষাটা not taken a printout. But before
Very bad. The last occasion I also
yes,
said.
after
that's
that only we have gone through it. It's in the downloaded in the mobile.
Lordship, this another judgment is one Supreme Court. Paragraph 8.
Yeah, 2001 Supreme Court paragraph page 136.
Based on what proposition? Which portion?
Para 8, it has been come up. The receiver application was rejected by the trial court.
ডাউনলোড করেছিলি তো বার কর তো ওটা খোলে কত বললি বার থেকে নিয়ে একটা বইটা বারে যা
বার থেকে নিয়ে চট করে। কিন্তু বাকি ছিল না।
One more judgment, Lordship, is a mix up, Lordship. So I just find out.
These are the proposition of law. What are you talking? You should, what
Lordship
is
was-
binding on us is the ratio of law declared by the apex court under Article 141. This is something which is not. It is
Lordship was
really an order under Article 142.
Lordship was asking me whether the share.
Only thing is that there is an agreement. The agreement provides for this. If there is any claim, whether the receiver is the proper remedy to be appointed in such regard. When you have a very limited interest or the
Lordship, the injunction granted by the
that
trial
is a
court
different issue. If there is
violation.
we are not assuming an advisory jurisdiction. Only on a proposition of law we are saying. If there is any violation, you have a remedy.
The majesty of the court has to be upheld. If the court grants injunction,
that is
asking him not to induct tenants, and he continues and go on collecting rent, then probably what I understand.
There was no fetter on the part of the plaintiff in collecting the rent. The injunction does not know
mention that he
nature, character, position, and creation of a third party interest. It does not talk about the collection of rent from the tenants. It simply talks about the creation of a third party interest.
Lordship is absolutely correct. But
That's
the
all.
position and
If
the third
there
party
is a
interest-
creation of a third party interest, you have a remedy.
Lordship, I kindly appreciate, Lordship, this kindly visual situation. The learned judge was what I can understand from his order is observe that when there was order, I granted injunction not to get possession and third party interest. If somebody violates, there is a provision of 39(2) where I can understand. But somewhere the court has also come heavily upon them that, okay, then I'm stopping you from collecting the rent. That what I can gather from the order.
Is it a proper, I'm asking, is it a proper order? If the court is satisfied that in violation of an order, they have created a third party interest, is it a proper?
Because their rebuttal to my application is a very simplicity. They have
It is not giving a premium to a third party to remain in the occupation without payment of rent.
Lordship, the only thing which is rather coming in my mind is that how it is prejudice. I'm just putting the question to myself.
Where is the ground this law of prejudice comes? I don't know a single judgment.
If that single judge bench order,
That
Lordship
is
has not
what
accepted.
we will discuss and will distinguish and say not a good law.
One third, Lordship, is a mix up. Because Saturday, Sunday, it was there. If I can come back tomorrow. So only one job
No, sir, nothing.
But I've called for the book from the library.
People's nowadays really.
I'm sorry, maybe I should have
my
taken a-
brother will carry an impression about the Premier
But
High
I'm
Court
extremely sorry,
or a
but-
chartered High Court like a Calcutta. That the lawyers are so inequipped. They do not work on the brief. They do not care.
প্রিন্ট আউট নিতে বলেছি প্রিন্ট আউট নিয়ে মোবাইলে একটা বার করে রেখে দিচ্ছি I should take the responsibility.
Lordship was saying that. Let me find out.
Well, I have found it right. It's the 1955 Madras page 4.
I know that. I told you.
Give me a more sense. I'm taking
On a left hand side page, the second column of the 1, 2, 3, 4, 5, 6, 7, 8, 9.
There is
All
a,
these
I was using
principles.
the judgment order, but I
Principles
didn't
have been given, which is reiterated in subsequent judgment, I think 1970 Mysore.
দেখ না বইটা কি হলো
That's the first judgment, and which is accepted till now, which is even by a Supreme Court reference was there, and the Supreme Court has also accepted.
Neither in the written statement they have provided what FAR has been increased, nor in their rebuttal to my application they have disclosed about these things. Simply sit and deny it, that's all.
Or subject to this is
And injunction violated. And then they are saying they will go collecting rents, they will enjoy the property income, and you just keep and sit as a fence sitter and you just sit there. Whatever orders passed by the trial court injunction doesn't matter.
Well, is it T.
That
Krishna
is why the
Swamy?
observation is there, the trial court.
It's T. Krishna Swamy Chetty versus Thangavelu Chetty. This one I called for the book. It's showing from the mobile.
What mobile?
Last time pointed.
No, pointed out there.
No, I indicated.
Well, immediately I went
Nobody
back.
even care to take a printout or even to carry a
Immediately
book.
I looked into it, Milord, and
Then you are satisfied. That's all. Will you not bring a book? And the court has to wait that you have sent the man to collect the book from the library, and then we'll have to wait for you.
sorry, but I should have.
Sorry, we can't. We are asking. No, definitely not.
One judgment of Supreme Court was there 2019. Yes. Judgment. One day also.
How many times a judgment?
I've never taken.
It is really
I've not never
at
taken
least I can share. My brother will also share. We are not groomed in a sarista where the court asks you a question and then you ask for an adjournment. I do not know. Give me a time. You should presume that what queries should come, it should be ready and prepared to answer those.
Whatever facts I have lordship placed, two judgment I have placed, but
then let us
Madras
decide
High Court,
nothing more.
Madras High Court lordship.
Sorry,
there was the guideline. These is followed for appointing receiver. There has to be distinguished also.
The instant appeal arises from an order dated 11/5/2023 passed by the Civil Judge Senior Division Shalda in title suit number 86 of 2020, by which application for appointment of receiver filed by the plaintiff opposite respondent is allowed.
আমি জানি তোরা প্রিন্ট নিয়ে রেখে দিয়েছি আমি আর ওগুলোর দিকে মাথা ঘামাই
Undeniably,
প্রিন্ট দিয়ে যেন দুটো সেট এখানে থাকে
there is a subsisting order of injunction restraining
শিখে মানুষ এগুলো শেখ কোর্টে আসছিস যখন হার্ড কপি গ্যাজেট ঠিক আছে
directing the parties to maintain status quo in respect of the subject property with regard to the nature, character, position of the same,
habit আছে সারাক্ষণ ল্যাপটপ আর মোবাইলে দেখে পড়া
and also
প্রিন্ট নিয়ে পড়বে
not to create any third party interests therein. The suit is filed for partition and separation of share in respect of the property which was admittedly constructed over the land jointly owned by the party. An agreement was entered into on 8th June 2010 containing a stipulation that the appellants shall provide an accommodation of 118 square feet in an habitable condition on the third floor of the proposed building to the respondent. stop. It further provides that in the event the FAR is found to be excess or excess in the event it is further stipulated. It further provides that in case the municipal corporation, Kolkata Municipal Corporation sanction an excess FAR, then in such event the respondent's allocation would be enhanced in accordance with law. Previously, the respondent took the stand that the agreement provides for allocation of 118 square feet area in each floor of the proposed building, for which we directed the agreement entered into by and between the parties to be produced before us. The said agreement has been filed, and the clinching issue discerned therefrom is indicated herein above. It is a specific stand of the appellant that in terms of the said agreement, an area measuring 118 square feet has been given to the respondent on the third floor, which is disputed by them, which is disputed by the respondent, that the area which is provided is much less than what was intended and or agreed upon. Be that as it may, it's a matter to be decided in the suit, to which we do not make any observations. We'll complete the order, but we are setting aside the order and remitting the matter to the trial court, keeping his right open to take an appropriate steps on the basis of those allegations. And the observations will not influence you. You're right. Yes. Because there is another bench at 1. It's a disposed of.
Well, at 2 p.m., I will just hand over a print copy of those judgments.
Yeah. Yes. The roster of the Chief Justice. No
Review-
mentioning.
Review of an order passed by my lords.
Give that. Somebody came in the morning and wanted to mention regarding that determination. What to do? We have to rise that.
Could have converged online then.
Yes.
Could have converged online.
No, we don't know because somebody came in the morning and mentioned, we say we will sit because that's a special bench constituted to take up that matter. So we sat at 1. If nobody has come, then we are not going to sit from 2 p.m. then. Anybody virtually, anybody has joined? Some Amitabh Mitro, I do not know. His name, huh? Have you unmuted? না আনমিউট দেখাচ্ছে সেটা ওনার না আমাদের এন্ড থেকে ওখানে ওনার নামে ওখানে গিয়ে গেলেই একটা আনমিউটের একটা পপ আপ করছে হ্যাঁ সেটা কি ইফ ইউ ক্লিক দ্যাট anyhow then we rise there is no matter
Yes, madam. I can read.
Very paragraph 17 straight. Emergency. इसका আমি দিয়ে দেবো একবার পড়ে নেবো we'll do it এটা রেখে দাও we'll do it we'll do it
Item number 10 is concerned, my other friend is here. Your lordship is here.
let us see ठीक है ना
But the plaintiff is the appellant before your lordship. The judgment of reversal. The trial court decreed the suit on the ground of reasonable requirement and defaulter and other grounds. And against that, the defendant prefer an appeal. And in the appeal court, they have taken a point. They want application under Order 16, Rule 14 of the Code of Civil Procedure is pending. Without dispose of the said application, the trial court decreed the suit. But my contention before your lordship that the trial court elaborately discussed the application and dispose of the same at the time of passing the degree, my lord.
where is the order by which this order 16 rule 14 application was disposed of which order order number 21/9/2021
Yes, my lord. Order number 51.
this was not placed before the no that was there it was not disposed of anyhow then later on by an impugned order was it disposed of impugned judgment
When judgment kindly see the trial court judge. Yes, my lord.
of the trial court judgment whether there is any reference of order 16 rule 14 application
My lord, the trial court came to a conclusion that the application is not maintainable. I have.
Where is that?
My lord, last page, my lord. Kindly see. My lord, kindly see page 15. A trial court judgment.
of the trial court judgment yes
My lord,
Read
I have.
by-
Yes.
Where it is said?
Well, I am not inclined to discuss the other case laws submitted by the both parties, as either they are not relevant of the fact and circumstances of the cases are not applicable to the instant case. I also like to state that the Rekha Sarkar is not a necessary party of this case, as already discussed, and so this court is not inclined to call her as a court witness. Accordingly, the petition filed by the defendant to that effect is considered and rejected. So, my lord, on this point, they have taken before the court below that the trial court has not disposed of the application, but it is evidently clear that the elaborately, my lord, the application was heard and this application was kept abeyance till disposal, till delivery of the judgment. And this food property was, my lord, taken by the defendant during the lifetime of my father. And, my lord, the said period has already been expired in the year 1999. My lord, there is a...
It is a 56 suit or a 97 suit or under the Transfer of Property?
My lord, the Transfer of Property Act.
Expiry of lease by flux of time?
My lord, there is an agreement for a period of 5 years. That agreement was expired.
I'm asking you expiry of lease by flux of time.
Yes, my lord. Thereafter not renewed the same. Thereafter not renewed. And one thing, my lord.
The suit is filed on the ground of reasonable requirement.
Requirement, defaulter, rebuilding and building.
Under 56 Act or 97 Act?
97 Act, my lord. No, 56 Act. 106, my lord.
Really?
Under the Transfer of Property Act,
Under the Transfer of Property Act, there is no concept of the reasonable requirement. You have said that you have pleaded, you have taken a ground of reasonable requirement.
Yes.
And the suit is decreed on the ground of reasonable requirement.
1997 Act, madam.
I am asking you, Transfer of Property Act, Transfer of Property Act.
No, 1997 Act. And, my lord, one thing, the property...
No thing. You do not know. Under the Transfer of Property Act or under the West Bengal Principalities.
No. My lord, one thing, my lord, the property belongs to my father. After during his lifetime, he executed will. The will was property. And, my lord, in the name of 2 sons, the appellant before your lordship and 1 brother. The brother, his share gifted to me. So I am the 16 share of that property. Rekha Sarkar is my daughter, with my divorcee daughter. So, my lord, divorcee sister. So, my lord, my father, while giving the lease, one clause is there, she will take in the rent from the... That is why, after demise of that and after the granting of probate, Rekha Sarkar has no right to collect the rent. Because already all expired. And I am the absolute owner of the property. So, Rekha has no right. They claiming that, no, we are giving the rent to Rekha Sarkar. Rekha is collecting the rent. As a result, they make an application order 60 rule 14 of the Code of Civil Procedure. The court came to a conclusion, they know. Because Rekha has no right to property, he has no right to collect the rent. But this is the point of law, my lord, whether I am asking myself, whether the appeal court can remand the matter on that ground, where the application was totally disposed of and hard lengthily. Lengthy, hardly, my lord.
Because it is an admitted position that the Rekha was collecting rent.
Yes.
Admitted position.
But I do not know. I do not know. Because Rekha has not expressed me before filing the suit that yes, I am taking the rent from the defendant.
Let us proceed that the lease deed, there is a clause which says that Rekha will collect the rent. If the Rekha collected the rent,
only period of 5 years.
From a tenant inducted by the father.
Yes.
Now you being the owner of the property, whether you can maintain a suit for recovery of possession. First. Second is whether even if the Rekha comes and say that yes, I collected rent, whether that takes away your right to seek an eviction on the ground of reasonable requirement.
Yes, I made an application. I pray before this court for requirement on the ground that I will my daughter is a divorcee and he is a sister is a divorcee and one grandchild is there. So for her new business be conceived.
You do not know where our minds are really heading. Anyhow, what do you say? How the court has rejected the trial court rejected the application. The application was rejected rightly or wrongly. That's a matter to be decided by the appellate court. Why the appellate court will make a remand for that only purpose, whether the Rekha is the witness, the court should. What is the language of Order 16, Rule 14? What is the language?
It has been set out, my lord.
What is the language of Order 16, Rule 14?
Someone as witness, strangers to sue.
Correct.
But a court.
It is a satisfaction of a court whether to issue summon or not to issue summon.
But subject to the provision of this court as to the attendance and appearance and as to law for the time being in force, where the court at any time thinks it necessary to examine any person, including a party to the suit.
Correct.
And not called as a witness by a party to the suit. The court may, on its own motion, cause such person to be summoned as a witness, to give evidence, to produce documents.
Now, question is, first thing is a suo motu power which the court should exercise. While exercising the suo motu power, the court is guided by the first part of the provisions.
Yes.
Where the court feels necessary that this person's version is very much required for the adjudication of the rights between the parties, for adjudication of any issue of fact or a law or whatever of nature. Then the language says the court may. That means a discretion is left to the court. The court exercises the discretion and found that this witness is irrelevant, not required. Now, the appellate court has to come to a finding that this particular finding of the trial court is absolutely perverse.
Kindly.
Suppose if the court has said it is perverse, then the appellate court itself could set aside that portion of the judgment, allow the application under Order 16, Rule 14, and then can remand. How the appellate court can remand for disposal of Order 16, Rule 14 application?
The language of the order number 51. May I place it? Order number 51.
Kept in abeyance till the judgment is delivered. I know. I am talking about the trial court's judgment, where the trial court has considered that application and rejected it. Come to the page number 15 of the trial court judgment. The trial court has considered that application and rejected it. It is not that it was kept alive or undisposed of.
But it says, I am not inclined to discuss the other case laws as submitted by both parties, as either they are not relevant or the facts and the circumstances of such cases are not applicable to the instance. I also like to state that Rekha Sarkar is not a necessary party to the.
Now, this is a finding because that is the first part, that his presence or her presence is necessary. If the court feels that presence is necessary, she should be called as a witness, then court may.
Yes, yes, absolutely. I vote on before.
So the court says not necessary. I do not find. I am not inclined to call her as a court witness. Do not want.
The appeal court could have done it. That
straight away. So appeal court has proceeded on a wrong premise that as if it is a pending. No, it was disposed of by an impugned order.
I vote on before. To that extent, my lord, that finding is an erroneous finding that the application before the trial court under Order 16, Rule 14 has not been disposed of.
Absolutely wrong.
Irregular finding.
Wrong.
Yes, that finding I put on before lordship. But so far as the party being a necessary party,
Now, are you ready on a merit proposition of law? Straight away.
I'll be losing a forum.
Huh?
Let it be remanded.
No.
Let the applicant
Now tell me. Let us.
before the first appellate court.
I am not on that.
Because if I argue before
I
lordship,
am-
then my client will be losing a forum. Let there be a finding to that.
No
effect.
losing a forum. This is what an exercise of the forum. Let us proceed on two premises. Argue on a proposition of law. Let us see. The Rekha is a very, very, very important witness. Very prime witness. What for she is called? To prove that I collected rent by an authority given by my father. She will not come and say, this is also not your case that the Rekha has inducted you. Your case is that the father of the Rekha has inducted you.
Father inducted me, executed
I am
a subsequent
coming. So the father, it is not that the Rekha inducted you. Let us see a situation. She comes and says, yes, I collected the rent. Even if this fact is there, can he, as an owner of the property, file a suit for eviction of a tenant on the ground of reasonable requirement? Tell me.
whether the point of reasonable requirement is at all available to the landlord or not.
On merit is a different. You lost. Appellate court also says no merit.
No,
on
appellate
facts.
court remanded.
Only on the ground. So far as the reasonable requirement proved, accepted. Did not say anything on that. Now tell me, on this score only, suppose we accept your version, what the Rekha will come and say? Only one thing.
But Rekha,
I collected rent.
yes, Rekha will. I will have to prove rent receipt.
But Rekha never inducted you.
No, Rekha remains my landlord.
Oh,
I have been indicted.
I am
But
against.
subsequently, by virtue of the registered agreement, my landlord becomes Rekha.
I am asking you, sir, very simple way. The inducting landlord has permitted Rekha to recover the rent from you. Visualize. Inducting landlord has permitted the Rekha to collect rent from you. If the inducting landlord is denuded of his right title and interest, or he transferred his right title and interest, whether the owner can maintain a suit for recovery of possession on a ground of reasonable requirement. Point is very simple. Tell us. Or he is permanently debarred from instituting a suit. Tell me.
But what has fallen from your lordship, but that the present landlord is absolutely absolved of his power to institute a suit for recovery of possession.
You may treat this till
I've not thought of that angle. Question now very critical. It goes to the very root of the case, as to the mental with the plaintiff itself. The plaint does not stand at all. If that is what has followed from your lordship, the entire plaint goes.
that is your defense. Let us see. We accept your defense. You have taken a defense just to deny his right. He cannot maintain a suit, not being my landlord. Sorry, I do not recognize you as my landlord. And that's the only point. This point I am asking whether you can, even if the Rekha comes and in your support says, I collected it. Let us proceed. Extreme case, presume whether that takes away his right to maintain a suit for recovery of possession. But just say it. এই এটা দেখো তো এখানে আছে ওয়েস্ট বেঙ্গল প্রেসিডেন্সি একটা অনেক বই আছে 2-3টা এই তো Let's be the this. Rent has not been given. Sorry, rent has not been given. Means any person by or on whose account on behalf of the rent of the 16th or this should not to be paid. That includes any person continuing on the so this is the landlord has notified. Yeah, C to C. Includes any person for the time is received or entitled to receive the rent whether on an account of or on behalf or for the benefit of any other person, or the trustee, guardian, receiver, for any person, or receive the rent or be entitled if the cases were later. So this is what is so now question is that if is due whom so whom you got the authority.
Now, in the plain, we have taken the point regarding the khas position also. We have taken the point. And prayer is there also.
Section certainly starts with a non-obstructive law that standing or any contract no favor of the except on the suit instituted on what for is not in condition of suitable accommodation. It is same as for the
acquiring interest in the property by the transfer and no suit for recovery of the number of requirement, building limitation or requirement for the survey instituted. This is a monitoring embargo for a period of 1 year. So you purchase the property for 2 So this is why the embargo was reduced.
Yes. Tell us. We will decide at the stage of admission. We will not keep this matter pending. That's why we directed service to be effected. It's a small point. Tell us question of law, nothing more than that. Tell us, everything will be decided here and now.
So there was nothing. So this is what
cannot be done, nothing of that. Yes.
Trial court, degree the suit on the ground of defaulter of payment of rent. So far as reasonable requirement is concerned, my lord, the more discussion, sufficient discussion has been made as to the reasonable requirement. Kindly see, my lord. To sum up, I am inclined to hold internal page 15. To sum up, I am inclined to hold that the plaintiff has been able to. Yes. Yes.
Yes, my lord.
Notarized.
No, notarized. Notarized.
Registered. Yes, registered. Yes, it is registered agreement.
তাহলে নোটারি বলে দিন ফট করে আমি তো রিক্সা জানি
Sir.
No, my lord, I have same. না আমাকে ডিক্টেট করো না আমি করছি করি আমার করার মতো দাও না তোমরা করো চলে যাও
This is the agreement. This is the deed.
আমি তো জানি এটা কি
Registered. Yes.
I know mala it is a registered document by some mala whispering mala has submitted. I am praying apology mala. It is a registered agreement for a period of 5 years. Only one point is there: the rent be collected my daughter, Rekha. After probate, I am the absolute owner of that property. That is why I pay for degree khas possession of the property. Date is agreement 23rd April 1999. After commencement of the Premises Tenancy Act 1997. But the act is they came into effect. But the no agreement is 1999. Effect. Yes. But the trial court, my lord, last paragraph, my lord, to sum up, I am inclined to hold that the plaintiff has been able to prove the ground of defaulter in payment of rent and reasonable requirement against the defendant, seen despite of service of notice to quote the defendant failed to deliver and handed over the vacant possession of the suit property. So I pray before the court for khas possession.
In one hand, the trial court says that the defendant has not taken any steps to call Rekha Sarkar to prove the documents, rent receipts. And on the other hand, the trial court says that he is not a necessary party. And so far as the default, Any day.
Tell us when you want. When you want, when you can come.
For final hearing, my lord, as your lord.
Even a preliminary hearing, you are not ready. I do not expect anything in the final hearing.
No, regarding the point is question, my lord, they prefer the appeal, first appeal. That appeal not maintainable. That appeal not maintainable because the application was disposed of. How the trial court come to a finding? Yes, remand the same.
Appeal is not maintainable.
Appeal is not maintainable because
Why not maintainable?
they have challenged the application which was disposed of. They submit that the
There was
application
a
is pending.
judgment, there was a decree by the trial court. The appeal is not maintainable. The grounds may not be sustainable. Is a different one.
They have
Appeal
filed
not
the appeal
maintainable.
on the ground. The application is pending. The appellate forum, first appellate court. Yes.
So why you say maintainable? Why not maintainable?
Maintainable question, they have not challenged regarding the entire judgment. They have challenged only the application.
A person can challenge
Regarding the appeal is question. Order 41.
Order 41 is the right about the flow.
Order 41 rule 11 the code of.
41 is the procedure.
Order 41 rule 11 of the code of. Oh, right.
So we have the word for it.
Section 100 of the code of civil procedure regarding the substantial question of law. No, here.
No. No. Where?
Yellow.
96.
Section 90C of the code of civil procedure. 6 of the code of civil. See, any party aggrieved and dissatisfied with the trial court judgment and degree, they can prefer an appeal. So here, the appeal file only on the ground that the application is pending. Yes. On the what ground? No, but one thing, my lord, the grounds not maintainable. But the grounds. At best, the appeal is maintainable, but the grounds taken in the that is not maintainable. Yes. This is the final submission, my lord, regarding the maintainability and no, regarding the appeal is right, but regarding the grounds taken, that is not maintainable. That is not sustainable in the eye of law.
14th.
My lord, 7th or final hearing or admission. I have understood, my lord. I have understood, my lord, the appeal be heard and the final discussion on 7th, as your lord. 11th, 10:30. 11th caption heading, order 41 or other. Order 41. Top, my lord. Top. One, item number one, as your lordship. Because already we have submitted, your lordship. That is why I am talking. And your lordship and I experience your lordship come to a find. And only 1,000 rent, 6 kathas of land in Barasat, near about 4 crores or 5 crores value. I am told, Junior. Only 1,000. 24 years there. Yes, my lord. Pardon, my lord. Pardon, my lord. Pardon.
No order, otherwise I will disclose that SMS. Okay.
That's all.
So item number 12, I am for the appellant lordship, I am paying for not to lordship. So lordship, in this matter, Mr. Probal Kumar Mukherjee is appearing. So he is not present in this court, lordship. He is not present in this court, lordship. He is engaged in another court, lordship. So I am paying for not to lordship.
No, he was also Sudip Pal Chaudhary, advocate on record, kindly, 12 and 13, your lordship, make it not to the next Wednesday, your lordship take up the matter. No, your lordship take up the matter. Mr. Probal Mukherjee appeared. Morning he was present, he was present, in morning, No, your lordship take up Wednesday, Wednesday, your lordship, both matter assigned before your lordship, Kindly, Wednesday. I am not in kindly Wednesday, Kindly Wednesday, not only for not to do. Yes, order for transfer. Because section here, that was not continuous recently allowed, yes, it was allowed. Or pass over, your lordship make it pass over, pass it over. No, no. Kindly, short pass over, short pass over,
Very short possible, my lord. I inform my lord. I have already informed my lord. Kindly make it very short possible. No, my lord, this is not.
My lord, I have prepared a genealogical table, my lord, to show the derivation of title, my lord. Renu, if your lordship kindly accepts this. Now, my lord, Renu Podo Dotto, my lord, he was the owner of the suit property, my lord, which was about, my lord, 5.9 acres. That, my lord, this by amicable partition, my lord, it, now, my lord, this suit was filed by, my lord, this Parvati Shen, my lord, who is the appellant before your lordship. Now, my lord, Lord, I should have. No, my lord. My lord, it was. Yeah, I should have done that, my lord, but it was there in the schedule, my lord, in the plane. My lord. My exclusive one. Exclusive. My lord, 3 daughters, two son and wife. Yes, ma'am. After 56. 1/6 share. Yes. My lord, I will, ma'am. Actually. My lord, let me come back on Wednesday, my lord. Then, my lord, my suit was my lord, this Parvati Sen. He has filed this suit, my lord, for declaration and permanent injunction and partition, my lord. Now, my lord, that suit was contested by my lord, defendant number 2, 6 to 8, and 16. My lord, there were 3 sets of written statements. Now, my lord, the trial court has partly allowed in the trial court, my lord, my suit was partly decreed. Decreed, my lord, to the extent that trial court declared that I am entitled to the amount of land that I am claiming by virtue of this free sale deed. But my lord, against that, my lord, I preferred a first appeal. And my lord, one of the defendant also preferred a cross appeal. Now, my lord, the cross appeal has been allowed, and my lord, my first appeal has been rejected by the court below. If your lordship kindly sees, my lord, in SA 440, no, my lord, my problem is this, my lord, the trial court was of the opinion that I am entitled, but after this purchase, my lord, when I sit for partition, my lord, then there was some dispute with the defendants. Now that, my lord, compelled me to file this suit. Now, my lord, the trial court is of the opinion that the amount of land that I have purchased by these three sale deeds. Yes.
What was the reason? How many decimals have? Everybody has 1/6 share, no doubt. No dispute. Purchase that share or part of it. Say that how things would file.
No, my lord, that was the only one aspect of the matter, my lord. That is the only aspect, according to your lordship. But in my humble submission, my lord, I have that there is no dispute that there are three sale deeds. Exactly. No, my lord. So, my lord, what your lordship is asking me to do is that I have to convert this 5.9 acres into decimal. $590, my lord. But 100.01 decimal. 1 acre is equal to 100.01 decimal. Acre. 100.01 decimal. 100. 100. So 500. Yes. $31. Roughly 1 acre. Roughly 1 acre, a little more than 1 acre. Total, because 93 decimal and 31 decimal, around 1.2. Yes, ma'am. Yes. Malad. Now, so far this share is concerned, Malad, the trial court has ensured my share of the property. But the appeal court has also, Malad, declined to declare this share of the property in my favor. This is the modified. This is, Malad, one of my grievances. And the cross appeal was also Malad, I have these. Well, these 3 sale deeds have been admitted. These are exhibited documents. Now, if your lordship kindly sees the judgment of the trial court, yes, my lord, if your lordship kindly sees page 29 of the trial court judgment, well, the last 2 lines, it starts, accordingly, the right, title, and interest of plaintiff, who is the appellant before your lordship, over plot number 431 of Mouja, Makrampur to the extent of 14.4 shatak, in plot number 3/710 of Mouja, Like Bazaar to the extent of 55 shatak, and plot number 431 such and such to the extent of 3.8 shatak is hereby declared, and she is entitled to get a decree of partition to that effect only. Well, this part has been challenged in the cross appeal. Now, the cross appeal has been allowed, and this declaration also goes, my lord, before the first appellate court. This, my lord, the learned trial judge has came to an opinion by virtue upon perusing those 3 exhibited documents which were my sale deed. My lord, senior, my lord. My lord. My lord, only one day, my lord. This is the first time I'm asking. My lord, first of all, my lord, I humbly beseech, so far the share of land that has been described in these 3 sale deeds, That I am entitled to, my lord, according to the learned trial court. My lord, that existence, even the respondent has not denied that there is no existence. They are saying that I am not entitled to purchase that. A non-partition property I am not entitled to purchase. This is the defense of the contesting respondent. My lord, let me serve them a notice, my lord, and come back. If your lordship kindly see the defense of the contesting respondent and the manner in which the trial judge has dealt with it, my lord, it starts from, I'm indicating you, my lord, the page. Lordship, trial court page number 19. May I read it, my lord? The said case has been opposed by the contesting defendants that from the record it appears RSROR was prepared in the name of Renupodo Dotto, and after preparation of the RSROR, he died, leaving behind wife such as such, the said heirs inherited the property from their predecessor in equal share. The case made out by the plaintiff that the amicable was. But after promulgation of the West Bengal Land Reforms Act, as per provision section 14 of the said act, the partition must require the registered deed of partition or a decree of competent court. And as such, the suit is bad for partial partition. Moreover, the mother of the plaintiff has filed another suit being title number such and such regarding self-same plot of partition, and that the plaintiff purchased beyond the share of owners, that she is at least entitled to get a decree of title in respect of said share. The excess share was incorporated in the deed, does not confirm any title on the plaintiff. Now, my lord, the observation of the Lionel trial judge, it starts from page 21. He has relied upon the exhibited documents, the 3 sale deeds. My lord, considering the submissions and perusing the records, it appears that through exhibit 1B to 1F, the property recorded in the name of Renupodo Dotto, the said fact has not been denied by the contesting defendants. It is also admitted that the said Renupodo Dotto died, leaving his wife Savitri Bala Dotto, 2 sons, and the genealogical table that has handed over to your lordship. From the exhibit 1B to 1F, it reveals that Khotian number 176 of Mouja Laik Bazar of plot number 3/710, recorded in the name of Renupodo Dotto towards. Then, my lord, in the said Khotian, there is no plot recorded in it. The PW1, through his examination in chief, has stated that after the demise of Renupodo Dotto, his heirs partitioned the said property orally. But in absence of any such corroboration evidence to that effect that cannot be accepted on solitary evidence, the plaintiff want to show that the said story of oral partition will be revealed from the deed of transfer executed by the heirs of Renupodo Dotto. The plaintiff, to establish her case, has filed exhibited as many as 9 deeds in this case, of which exhibit 2 executed by one daughter, Sundharani Dotto, in favor of the plaintiff, measuring 62 sotok of land in plot number 413 of Mouja, Mokarampur, and 31 sotok of plot number such and such. In the said deed, there is no such whisper about acquisition of title by the vendor of plaintiff by way of inheritance and by virtue of amicable partition. The acquisition of title as described by said Sundharani Dotto, Amar Shottiyo Dakhaliyo Sampotti. The said acquisition of title does not support the case of the plaintiff about acquisition of title by way of amicable partition, which was inherited. The only exhibited 3B and 3C, the plaintiff acquired title from Chayarani Boot by way of purchase, speaks that the said acquired by her by way of inheritance, subsequently by way of amicable partition among co-sharers. As such, the argument which raised by the plaintiff about admission of other co-owners of acquisition of title by oral partition have no stand and at all acceptable. The principle which shown by the is correct. So, my lord, the learned trial judge has came to an opinion as such by way of purchase, the plaintiff is entitled to get decree of title only in respect of share of her vendor. Accordingly, she got right title and interest in plot number 431 to the extent of 14.4 shataks, plot number 3/71 to the extent of 55 shatak, and in plot number 435 to the extent of 3.8 shatak of land, and she is entitled to get a decree of partition in that share only. So, well, this has also been, this observation of the trial court has also been turned down by the first appellate court. Well, at least at most, but the quantum of land that I have purchased by these three sale deeds, which the learned trial judge, that, my lord, I am entitled to. No, my lord,
To the extent of what my vendor had.
the appellate court has told, subject to correction, my lord, that I am seeking partition. No, the first appellate court has came to a conclusion that I am seeking partition to a particular plot of land which which is excess to my sale deed, my lord. The sale deed, the quantum of land that I have purchased by virtue of the sale deed. Now, in the partition suit, I am asking for seeking declaration of my share, which is not akin to that the amount of land that I have purchased by virtue of the sale deed.
I'll put as head that how much I have purchased at page 25 in the next step. It is the কোনটা আছে that 469 469 is the next step. The corresponding 440 তে এই finding টা আছে নিশ্চয়ই। How much the plaintiff more or less acquired this? আগে ট্রায়াল কোর্টের ফাইন্ডিংটা কতটা আছে?
Page 16 of the appeal court session. জজকে পরে appeal করতে
ordering portion.
page 16 টা না এটা হ্যাঁ appeal কোর্টের এতটা পরে এই দেন If your lordship kindly permit me to interject, my lord, your lordship is producing a memo of appeal of 440 of 2016. 440 of 2016, your lordship is going through the yes. If your lordship kindly, because there are some 440, my lord, the next, the analogous appeal, my lord, 469 of 2015, my lord, the judgment and decree are same. Yes, my lord, if your lordship, Yes, yes, that if your lordship, kindly takes up 469, then my lord, I can request my learned senior to assist your lordship, because this 440, my lord, this brief is not with my senior, my lord. So because the pages are different. To- Yes, my lord. But it is not, my lord, both the are not same. Page 16. It is admitted. But kindly give me a minute. Sure.
May I just, Lord, if your lordship takes up the next appeal, Lord, I'll be very precise. My argument is the trial court comes to a finding about, Lord, what my client, Lord, acquired. He has Lord, found out the extent of, Lord, my client's purchase. He partially decreed the suit on partition. Although I claimed partition in respect of 11, Lord, he found that I have, Lord, title in respect of 3 plots to such extent. But my point before your lordship that the appeal court could not have, Lord, dismissed my suit. At least, Lord, the appeal court could have determined, Lord, what share I had in the plots of land. But that has been done illegally. Because I say, why? Because the trial court's findings so far as the acquisition of title in respect of the part of these 3 plots of land, that is not the subject matter of appeal. They are subject matter of appeal in the cross exam. That they say because it is the suit is bad for partial partition. And I could not show my title in respect of 11 plots over which I claim partition. In respect of the 3 plots, Lord, I am entitled to get a partition decree. Lordship. Yes. Equal to page 14. It is admitted that after demise of Renupada Dotto, his widow, 2 sons and 3 daughters acquired 1/6 share of each. Then Section 8 of the Transfer of Property Act says that transfer of a property passes forthwith to the transferee. All the interest which the transferee is capable of passing in the property and in the legal incident thereof. Therefore, the so-called vendors of plaintiff appellant did not have the capacity to transfer more than that of to claim partition as co-sharer. Thus, in my view, learned trial court was not justified in passing the impugned judgment. Then kindly come over to the trial court's judgment. Very well. Lordship. Lordship. Lordship.
Purchased well demarcated land.
Similar to purchase of a well demarcated land doesn't mean that it has been partitioned. But it has to be by a declaration and subsequently by mits and bounds. Because, the trial court says in respect of a particular Dag number, I have purchased a portion thereof. Your lordship will find that, in the other appeal, the findings of the trial court at page 24. Page 24 and 25. But that I understand, Lord. There cannot be a oral partition. There cannot be. That's the reason, Lord, my client has sought for a partition, Lord, by way of a suit. The oral partition, Lord, that is not, Lord, legally recognized. But all that I say before your lordships are, Lord, when the trial court is of the opinion that this much of, Lord, these 3 plots have been acquired at page 25, he has, Lord, come to a conclusion. The appeal court, Lord, perfunctorily said, no, you don't have a case and it is liable to be dismissed. Page 25, Lord, of the trial court. It starts from 24. The learned judge has calculated based on, Lord, the deeds, the area calculated in respect of the plots and gave a partial partition decree. I mean, Lord, the partition in respect of some of the plots. The appeal court, Lord, dismissed that. So, Lord, if I am unable to, Lord, show before your lordship, Lord, my title in respect of, Lord, the other plots where I claim partition, I am not entitled to it. But for those where I have established, Lord, I am entitled to a partition. I'm grateful. My lord, application কিছু ফাইল করেছো? কিছু অ্যাপ্লিকেশন ফাইল করো? ও ডিসমিস করেছো? লর্ডস, তো আর একটা অ্যাপিল আছে তো সেটাও তো তাহলে 47 আর একটা অ্যাপিল আছে এটা বাসন্তী দুটোই বাসন্তী ভুল করে লিখেছে ভেতরে হচ্ছে পার্বতী ভুল লিখে পারলাম Filing of the paper book will be January. Lordship. By end of January. Okay. Achha. appeal আছে ওটা যদি না থাকে
I for the respondent. I for the respondent. Okay. Last week also it was called up. The lordship was supposed to call the matter last week also. They didn't appear. নামটা নেই।
Lordship for the applicant. Checked, your lordship, not checked. Yes, your lordship. Missed, your lordship.
মারা গেছে মারা গেছে একটা দেখেছো মারা she has died. It is during pendency of the suit, the defendant number 3, Koel Singh, died unmarried on 12th of April 2014. Application was filed to that effect. But Yes, my lord, this application was filed, my lord, in appeal. Title appeal number 3 of 2015. No, no. Here it is written, my lord, he has died on 12th of April 2014. তো দেখো এটা দেখো ডিক্রিট ডেটটা ট্রায়াল কোর্টের ডিক্রিট ডেটটা কবে? Trial court's decree is, my lord, 29th of August 2014. And she has died, my lord, 12th of April 2014. They are prior to decree. But that application was filed to that effect for deleting of her name. Well, that application decree nahi to naamta. But for that reason, my lord, in the appeal court's decree, name is not there. My lord, the appeal court has dismissed my suit. The trial court decreed this suit. Judgment of reversal. Judgment of reversal. Suit for declaration of right title interest and for an injunction restraining the defendants from disturbing my peaceful quiet. My lord, the trial court, my lord, come to a conclusion that earlier suit, which was filed by me, was dismissed for non-prosecution or, my lord, dismissed for default. My lord, since it was not been adjudicated, this was not adjudicated, therefore it will not be barred by res judicata. That finding is given, my lord, by the trial court, and, my lord, decreed my suit after considering on merit. My lord, appellate court has said, my lord, the suit is not maintainable because, my lord, so far trial court's observation, yes, appellate court's order is, my lord, and last page it has said that since it has been order 9, rule 9, it is my lord, page 30 and page 31 is the conclusion. Conclusion, having been empowered under Order 40 and Rule 24 CPC, the court is inclined to determine the suit finally instead of sending the suit remand, which serves no purpose. From the above discussion, I find that suit is not mental in its presence form under Section 9 of the CPC, barred by Order 9, Rule 9 of the Code of Civil Procedure. The suit is liable to be dismissed, being not maintainable in law. For the reason as discussed above, I am the opinion that the impugned judgment and the suit. But since the earlier suit was dismissed for non-prosecution, therefore, my lord, unless I pray for restoration, the independent suit is not maintainable. That is the view of the learned judge. My lord, প্লেনটা রাখবেন। No, my lord, that is not with me. But my lord, I have got the written statement filed in that suit admitting my claim. The defendant number one at my lord. Yes, so for the earlier suit, title suit was 17 of 90. It was admitted position that it was dismissed for default because I did not take any step. No. In that event, my lord, kindly give me some time, I shall come back with that. Why? Because, my lord, the defendant number one in the earlier suit filed her written statement admitting. My lord, I am not claiming through the deed of gift. The other side is claiming through the deed of gift. Yes, yes. Yes. Where the, my lord, where the donor appeared in the suit as defendant number one and filed her written statement accepting that she did not execute the deed of gift. And, my lord, by practicing misrepresentation, my lord, since the situation that defendant number one who executed the deed of gift, my lord, filed the written statement. No, my lord, what is this? What was the situation? I did not proceed with this suit. My lord, since the issue has not been decided on merit, my lord, that is the Supreme Court's view. Not any circumstances, I can't say, but if this cause of action same, it has been stated, my lord, that where a suit is wholly or partly dismissed under order rule 8, the plaintiff shall be precluded from bringing a fresh suit in respect of the same cause of action. My lord, cause of action and issue are not same. Yes. On the same cause of action. My lord, suppose I am enjoying. No, it is not a date, but the occurrence, the situation, the incident. Yes. Man. Man. Because why? But the defendant who executed the deed of gift, but admitted my case that the deed has been obtained by practicing fraud. But in the second suit, plainটা কোথায়? cost title ব্যাপার। In the second suit, my lord, the executor of the deed is not there because she has died in the meantime. The other persons, my lord, are disturbing my position. Since the donor has, my lord, admitted that she has not executed the deed, that was the reason that I did not proceed with the case. If, my lord, defendant number 1 came and, my lord, filed the written statement, no, I have. We are learning from my lords. My lord. Yes, it's a blunder, no doubt. But even if, as soon as my respectful submission people, as soon as defendant number has filed the written statement contending that she has not executed the deed of gift, I should take, my lord, proper step to get the decree on admission. No, my lord, at least the executor would be with me. Well, it will be. Well, it will be. Well, in that event, I was in a better footing. That deed has been obtained by practicing fraud. Before, in that suit, in the earlier suit. It depends upon situation. It depends upon situation. No doubt to that. And the trial court has discussed this, my lord. page 14 of the trial court's judgment. Trial court has my lord decided that is not barred by res judicata. And yes, therefore, my lord, so for the res judicata part is a different thing, and this maintainability of the suit because of dismissal under order in rule line. But only thing, my lord, I have with me, my lord, the written statement. My lord, kindly consider this written statement filed by the defendant number. And so far, order 9, rule 9 is concerned, my lord. Only thing is, my lord, so far I understand, my lord, the order 9, rule 9, if it is dismissed in order 9, rule 8, my lord, fresh suit is not maintainable if it is filed on the self-same cause of action. My lord, kindly consider the first suit was filed in the year 1990 and the second suit has been filed, my lord, after lapse of 7 years. After lapse of 9 years, it is of 1999. Therefore, cause of action is not same. But instead of filing this 99 suit, if you file the order 9, rule 9 application, that will be a lot better. That in this situation, I have not filed proceeded with the suit because the defendant number accepted my contention. That will be better, but the client has not been advised so. Only thing as well, cause of action. প্লেনটা দেখতো প্লেনটা কত পার্সেন্ট বিল লিখেছি আর এই প্লেনটা কি কত পার্সেন্ট লিখেছি এইটা হচ্ছে আগেরটা party ছিল ওই মামলায় But the cause of action of the first suit and the cause of action second suit are not same. Parties are also not same. Well, kindly consider the Pradeep Kumar Singh is the defendants in the present suit. And in the earlier suit, well, he was not the party. Pradeep Kumar Singh. No, he was not the party. These are the two plaintiffs. Plaintiff is same, Gautam Rana. In the first suit, the Sabarmati Singh. But cause of action is different. My lord, kindly consider this. And my lord, it is only kindly visualize the situation why I did not proceed with the case. It is not that on my whims I did not proceed. Yes, certainly. My lord, Order 9 Rule 9 says if it is dismissed under Order 9 Rule 8 on the self-same cause of action, I shall not be at liberty to file the suit. I am barred to file a fresh suit on the self-same cause of action. But the cause of action is different. But cause of action and issue are different. Therefore, the cause of action here, my lord, issue may be same. Here in both the suit, issue may be same, but cause of action is not same. My lord, kindly consider only because of this situation I am in position. মারা যেতে হবে এয়ার স্ট্রাইক ব্যাপারটা
The persons claiming to the donor as claiming their identity based on the basis of the corporate deed of by implicating the donor itself. Donor has the donor was treated as the first categorically and stated that the income given is not valid. Yet, some difference having surfaced allows for all nine all seven after gap of That is, solution of right and that we of him not value. It was initially made by the Crown Court on the ground that the issues were not however, the appellate court based upon the same set of facts containing the argument it's not going to for the appellate side that the moment issues have not been finally determined by the court, the of rescuing or weakness or stop does not come to play, and therefore the appellate court have come to the great error in holding that it is not a subject that there is a distinction between the issue and the cause of action, which cannot be intermingled nor not included within one cause, and therefore the appellate court must take into account that the part relates to a cause of action, the part of the interpretation, yet only apply provided the subject based upon the theme or the rights. These are subjects having importance. That the belief that should be involved in the as its independent and separate existence. They should involve their and if decided by the shall act on the people of this will be straight number in the subject. The is based on policy of the country that everybody must require the victim. And the issues which have already been decided by the court finally should not be reopened nor the person can be permitted to because one of the cardinal duty of the estoppel when on an issue and commonly referred to as the issue by estoppel by issue had no hesitation in our mind that apply within the four but we have but the hazard way had that we are also conscious and aware of this description. The principle of predictability of the and the informal creativity. The bar is for the cannot be treated as a key of principle of predictability. As all of the concept of the computational authority on the other hand, the the quality of the and the determination of ascertaining the issue or in the context and bringing it and bringing a valuation of or it is malicious to bring both the concepts within singular bracket when undeniably both operates in a different sphere or in a Alternative A postulates that on a day when the material the equipment appear or the printer is not appear. The report they either not beginning or alternative line creates an embargo based on the cause of action. Being similar to that of the others. In the event is under the of modern our attention is brought to an exhibit 5. Being the order by which Douglas therefrom that on the day when the system of distress or required disappear and therefore such a system was under the key of modern life and accepts an embargo created under the line of modern life of the court. far as the further action and the issues are concerned, it is undeniable that the further action has not been defined in this statute. Rather, this is the concept and its advancement from our law principles. It is uniformly defined as a bundle of facts treated by a plaintiff in support of the relief claim therein. Fighting the cause activity. It cannot be said to be a single fact or a deed, but the entire facts needed in the is required to be deciphered and therefore that deciphered which the needs are played. The earliest root for this on the premise that the right interest have been shrouded by an act of the defendant. They on the basis of a legal gift. The further action relates to a denial of patent by the defendant on the strength of a legal gift, and therefore the further the issue which might have or would have been on the basis of the facts. Some conflict. Making the right representation. He holds the legal gift and therefore we do not write applying of complex ordinary is the flow purely that the audience but we obviously find that the this title language has been done based on the other action. The purpose cannot be segregated separately and remains part of the therefore, is
He's saying, my lord, today is not good day because my matter has been dismissed. Only.
Right. Tomorrow. No. Judgment of affirmance. Declaration of title permanent injunction. Defect. Yes, my lord. Last occasion I have handed over the copy and it has been stitched pursuant to your lordship. Wait, tomorrow is not taking up. My lord is taking up order. Yes. Tomorrow, my lord. This is from tomorrow morning. That's gone now. 41 columns.
Yes, we have paid the money. Construction having. Yes, but Kushal, the learned advocate for the respondent said that.
My lord, item number 9 was passed over today because I was not present here. I was in courtroom number 41. My lord, lordship, Wednesday, lordship. Tomorrow, lordship. Lordship. Deeply obliged, my lord.